Well, good afternoon, everyone, and welcome to this very important WRA Legal Update Live. I'm Mike Theo. I'm the president and CEO of the WRA, and joining me today is Tom Larson, who's our executive vice president, and Corey Lamont, the WRA senior director for legal and public affairs. Today, we're going to take a little bit of a deeper dive into the issues and some of the potential impacts of the recent decision in the Sitzer Burnett case in Kansas City involving the National Association of REALTORs. Today, we hope to cover in the next 30 minutes the issues that are involved in the case, the verdict, and the potential impact of the case. In particular, what it means for Wisconsin realtors given Wisconsin law. We'll talk a little bit of some of the WRA responses and recommendations that we have for your interaction with customers and clients moving forward. Please, if you ask your questions, we do not have the chat box open. Please use the question and answer, the Q&A tab at the bottom, and we will take up your questions and answer them with the time remaining. If you don't get an answer to the question you've submitted, we'll be answering those after we finish the broadcast. And if that doesn't work, you can always feel free to use the WRA legal hotline. So again, welcome, and I'll turn it over to Tom.
Good afternoon, everyone. We want to start off the program by just giving you some background on the lawsuits that have been filed. There have been two class actions lawsuits filed by home sellers against the National Association of REALTORS and several defendants. One of those lawsuits is the Sitzer Burnett versus NAR lawsuit that was filed in the state of Missouri. The other is the Morrill versus NAR that has been filed in the state of Illinois. Both of these cases are federal lawsuits, and so they've been filed in the federal districts in those various states. Both cases were filed in 2019, and both name the exact same defendants. And in addition to NAR, there are several real estate companies and also several MLSs. Now, the lawsuits all have a very similar claim, and that is that NAR's participation rule, which requires the seller to pay the buyer broker's commission, has led to artificially fixed and inflated commissions and increased buyer costs and higher home prices. Now, the plaintiffs claim that the NAR and the other defendants have conspired to inflate the commissions by requiring all the seller's brokers to make a blanket, unilateral, non-negotiable commission offer to all of the buyer's agents. And they're saying that is a violation of the federal antitrust law. And then we've had these, before the jury verdict in October, we had two of the real estate companies enter into settlements. And the settlements were for $83.5 million for the Anywhere company and $55 million for Remax. Now, these settlements were entered into as an effort to limit liability in future copycat lawsuits. And the settlements are not finalized yet. They've been submitted to the judge, and the judge is reviewing them. But the underlying premise and the reason why the companies entered into those settlements was to protect themselves from future litigation in other lawsuits filed in other places. And as we all know, the jury in the Sitzer case, the one filed in Missouri, came back with a verdict on October 31st. This was a trial that lasted for about 2 weeks, and the jury deliberated for only a couple of hours and came back with some pretty high damages. The damages that the jury awarded were $1.78 billion. But under federal antitrust rules, those damages are called trebled damages. And that means that the damages that the jury identifies are automatically tripled to be approximately $5.4 billion. And it is our understanding that the defendants that are remaining in the lawsuit are jointly and severally liable for that $5.4 billion, meaning that the plaintiffs can go after each of the defendants separately or jointly to come up with the money to be able to pay for those damages. Now, a final order has not yet been issued. And I think that's important because while the jury has come up with the damages, we're not clear yet whether the judge is going to issue some other limitations or requirements on NAR or the parties that are involved. So that's something to watch for. They could place limitations on the future use of the participation rule. They may place some limitations on what cooperation looks like or the disclosures that need to be made. We're not yet clear about what may be in the judge's final order. The other thing to remember is that this case will be appealed. Once the order is finalized, NAR will be appealing this case. They're already working on the appeal, and they feel confident based upon some of the proceedings that have taken place that they've got a very good argument for appeal. And the appeal is going to take some time, approximately 1 to 3 years to resolve before we get a 3-judge panel, which is a panel that decides appellate cases will come up with a final decision on NAR's appeal. A third lawsuit was filed on the exact same day as the jury verdict in the Sitzer case. And it was also filed in Missouri by the exact same attorney involved in the Sitzer case, but they named new defendants. NAR was named again, but they named new companies, and the companies are listed here on the screen. And this is a case known as the Gibson case. That's one of the names of the plaintiffs involved. Again, there are more home sellers involved in the litigation. And the claims are essentially the same as the other two cases. Again, going after NAR's participation rule. Now, Corey is going to talk about what this case means for Wisconsin, and what it means for your companies and what it means for your practice. She's also going to talk a little bit about why we feel that Wisconsin's law is unique and may provide better protections against copycat lawsuits against realtors in the state of Wisconsin. Corey?
Thanks, Tom. So as Tom indicated, we're not necessarily sure everything that's going to come out when the judge's order is issued. So this is all just potential and possible impacts that might be reflected either in discussions or practices or from the judge's order. One of the things that Tom indicated, it's possible that the continued use of NAR's participation rule may be suspended, may be modified. In addition, MLSs may not require realtor membership, which is happening currently in other states. So that is something that you may see. In addition, you might see buyers paying the buyer agent's fee or some other kind of alternative as buyers kind of work their way through it. In addition, one of the concerns that Tom referenced was a copycat lawsuit. We're hearing about rumblings. This has always been a concern. So what do the copycat lawsuits look like? And then mandatory buyer agency is another discussion that you're hearing. So there has been suggestion that maybe buyer agency ceases to exist because if the conversation is about sellers paying buyer agent's fee is kind of the talking point, even though, again, we all know how the MLS offer of compensation works. While some believe buyer agency may cease to exist, others believe that mandatory buyer agency is the only way to go. And that's actually where 15 other states have either recently passed legislation or are currently working on legislation as one of the methods that they're kind of responding to this. As Tom mentioned, in Wisconsin, we do believe that we are slightly unique in the fact that we do have state-approved forms. As you know, all of you are required to use those WB forms. Those are created by the Department of Safety and Professional Services, the state agency through the Real Estate Examining Board. So a number of other states don't have state-approved forms. Those are created by a state agency that's there for consumer protection. So that creates a strong argument that consumers have been informed, that there's consumer transparency. We further believe that Wisconsin state-approved forms have strong consumer transparency as it exists today. So as you're well aware, you have your listing of buyer agency contracts have blank lines for commission. They're not representing that it's non-negotiable. In addition, your listing contracts have the compensation to others language, where as a listing agent, you're talking to the seller about this is the amount that I will be paid as a firm, our firm will be paid, and then this is how we are talking to you about ways that we could compensate others. And then, of course, your buyer agency agreements also have a discussion about the buyer providing consent to receive payments by the buyer's agent from the seller or seller's agent. Again, a number of other states don't have these types of state-approved forms, let alone maybe written buyer agency agreements, and don't necessarily have these types of more consumer-based transparency in the commission discussions and payment of commission. And again, in Wisconsin, buyer agency is strongly encouraged. And so that is another reason that we believe that we're well positioned. As far as WRA's response to litigation, our board of directors very quickly and proactively wanted to start having discussions as much as possible, as much as they could, about what next steps should occur. And so one of the things that we were directed as staff to do was retain outside legal counsel that is an expert in antitrust law. We have one of the more foremost antitrust experts in the state of Wisconsin providing guidance, kind of looking at the forms, looking at the state laws, looking at vulnerabilities that one could suggest as a plaintiff's attorney. And so what we did as a state association, as a legal team, is we were responsive by looking at member risk reduction. And so that is why you started hearing WRA creating and promoting the use of this addendum C, which is talking about commission transparency. Again, we believe that the current WB forms already have a good amount of consumer transparency. So this form was created just to bolster or boost consumer transparency. In addition, while the addendum C was being released, WRA was actively recommending to the Real Estate Examining Board and the state of Wisconsin that they consider further enhancing consumer transparency within the listing contracts, buyer agency agreements, and tenant rep agreements, which is why you will now see those forms updated with an optional use date of December 1st, 2023, and a mandatory use date of January 1st, 2024. Those will include commission language, similarities, just like you see in the addendum C that WRA has created, also encouraging dispute resolution and not necessarily going to litigation right away. And then also a notice about the Wisconsin statute of repose, which essentially creates a 2-year limitation on liability relating to your real estate transactions. In addition, we have been directed to create a buyer agency work group to kind of look at this as a bigger scope as to whether mandatory buyer agency or further improvements could be created in the buyer agency agreement. I think the biggest question that we've been receiving as a legal team, as a staff here, is kind of what do we do now as real estate licensees, as realtors in this state? And these are steps that the legal team has worked through. This is what NAR's legal team is also supportive of. The idea that we're kind of continuing to communicate that there's not a standard commission rate, which is what you're seeing in your addendum C, which is further going to be in the WB forms. Talking about commission is another big conversation that we just want to make sure you're having. Discuss, explain about the commission. Avoid pre-printing is a directive that NAR is saying, making sure that people understand that sellers and buyers, that there is a negotiable element to commissions. And then do not suggest nor portray that buyers' agents work for free. That has been a claim by the plaintiffs' counsel that buyers' agents have been walking around saying, yeah, we work for free, when really the conversation is slightly different about how you're getting compensated, which then compensation to others in your listing contract, having that conversation as well, discussing and explaining, and then again, avoiding pre-printing information in there. Again, having the conversation with the seller about compensation to others. And then, of course, one of the things that you want to avoid and you continue to avoid is steering buyers based on the compensation that is offered. And so There's obviously varying amounts of compensation to others and making sure that buyers understand they get to see the property that fits their needs, not necessarily what would somehow be a preferred compensation amount from the perspective of a real estate licensee. And then continue to use WRA's Addendum C until the WB forms are available for your use. And so again, those will be mandatory January 1st, 2024, and we will continue to keep you informed about those. One of our goals here was to make sure that we can answer your questions. As a reminder, we are facilitating questions through the Q&A, and so feel free to post those and we will be happy to respond to those.
Corey, I think the first question comes about buyer agency. And the question is whether or not the plaintiffs are concerned only with buyer agency, or whether they're also concerned about subagents. In other words, would there be a lawsuit if there was no buyer agency? And I'm going to take a shot at answering this first, and Corey can chime in and correct me if I'm wrong. I guess my thought on this is that this is a lawsuit about transparency. The nature of the lawsuit is that neither the seller nor the buyer were aware of how commissions are paid. And one of the most important things to come from this, one of the most important changes in terms of practice, if you've not been doing them, is to discuss options. Options with your seller for what they can do with respect to buyer agency and offering a commission to the buyer agents, and also with respect to subagency as well. I think this issue of transparency and discussing options is not limited to just buyer agents. It would also apply to subagents. So remember, the lawsuit is generally about transparency and the feeling that consumers are not well aware of the options that they may have with respect to offering compensation to buyers agents and likely subagents as well.
I would agree. The three major cases that we have right now are all from the home seller perspective, which is why I believe that you're hearing more about the buyer agency. But to Tom's point, it is important that we are just having broader conversations about how commission works and how commission is paid out to everyone on all the sides. There was also a further question about how will this affect VA buyers with buyer agency. Of course, we all know or are mostly aware that buyers, they can't pay buyer agency fees. That's a great question. I think one of the things that you'll start to hear more chatter about is this idea that if buyers have to start or are expected or anticipated to pay out of their own pocket the buyer agent's fees, there is likely going to be a conversation about how that's facilitated. There's a suggestion that maybe there'll be some sort of lobbying effort made on a national level to see if those can now be placed in the as well as VA and FHA, as well as conventional, this idea that you'd be able to receive some sort of funding as a buyer to be able to pay your buyer agent's fees. So again, not a ton of answers at this point, just again, possible outcomes that could occur.
Corey, there's also a question about making membership to NAR optional. And as most of you know, there's what's called a three-way agreement, which requires realtors to be part of a local association, state association, and national association. There's been some talk that maybe one of the impacts of this lawsuit and the large damages that have been awarded, that there's some possibility that NAR is insolvent at some point in the future, and that realtors would have the option to join local association or state association rather than NAR. Just one thing to remember is NAR owns all of the trademarks, all the realtor trademarks, and that's not owned by state associations and local associations. So it's not clear what would happen with the realtor trademark and the use of that moving forward. But on a macro level, with respect to, let's say, membership is optional, whether it's at the National Association, state association, or realtors or local association. The WRA Board of Directors several years ago adopted a strategic plan that said we should tailor all of our services as if membership in the WRA and the realtor organization was optional. By that, they meant we want to make sure that all of our services provide value to the member. that they help make their businesses more successful, and that we only provide those services if they're truly valuable to the members. So I think that has put the WRA in a very good spot to start thinking about our value proposition to members. And with respect to all of our legal services, advocacy services, education, and otherwise, our board and our team feel like we're in very good shape to talk about that value proposition. Mikey, you have anything else to add on that one?
No, I think it was great to note that we did spend a lot of time on this in the strategic planning process. And by doing so, we had no idea about the outcome of these cases, but we did think that it raised the point of us revisiting that value proposition and making sure that everything we do has a direct tie back to the business success of our membership. So very important. And I think it started us thinking the right way, regardless of the outcome of these cases, the eventual disposition of these cases.
There's an additional question in the system about whether we are recommending that you have buyer agency agreements signed prior to writing the offer or prior to showing homes. If the expectation is that you're going to be providing client services, you would do that as quickly as you're going to want to provide those client services. So in an ideal world, if your buyer is going to be your client, you would sign your buyer agency agreement. And so you'd have those conversations. Tom, there's a question about the potential of increasing the license requirements as a consequence of this. The idea that maybe there should be a college degree or something else, a minimum sales requirement per year or something along those lines relating to competency. Thoughts on that?
So raising the bar to professionalism has been another priority of this organization for some time. And we've looked at ways of doing that and trying to enhance the not only the requirements to become a real estate licensee, but how do you provide meaningful professional development once you do become a real estate licensee to ensure that you are providing a high level of service to your customers and clients, especially as part of the realtor organization. So we have not looked at this issue in the context of the lawsuits and whether the lawsuits necessitate a revisiting of those requirements, but we looked at it as an obligation and an opportunity to continually raise the bar to ensure that the customer and client is best served by very competent people who are engaged in the practice of real estate.
As far as the question relating to the jury decision didn't come along with any changes relating to the NAR rule requirements, what are our thoughts about that? Again, the final issue or order hasn't been issued by the judge, so there's a possibility that you could see some sort of obligation that the rules are changed, or there could be an NAR position that modifies that. So at this time, that's one of those types of questions we don't necessarily have the complete answer to, but it is a possibility.
And Corey, just one note on that. We actually anticipate the final order including something with regard to NAR's participation rule. It only makes sense that if the judge and jury believe that that participation rule is somehow a violation of antitrust, that they would try to limit its usage even while there's an appeal. NAR would likely ask for a stay of that component until there's a final decision made by the Court of Appeals. So just watch for that to kind of play out throughout the appeals process.
There was one noted concern about mandatory buyer agency. Will agents be able to work with both buyers and sellers in the same transaction, one as a client and one as a customer? Again, I think that's one of the reasons that the board of directors wanted to have a buyer agency work group so that we could explore those types of discussions. The consequences, will dual agency cease to exist? Or what will sub-agency look like? So a very good question, and one that we are going to be looking into. Likey and Tom, either one of you might want to take this one. Are there any financial risks to individual NAR members if the judgment stands?
Well, I think that's a really good question, both from an organizational standpoint and from a member standpoint. I think if it would be safe to say if the $5.4 billion judgment was the final disposition of the case, that NAR wouldn't have at this time the financial wherewithal to pay that kind of a fine. How they would go about doing that would be interesting, and whether or not they would turn to the members. They would liquidate assets that they could liquidate to come up with the funds, but that's all being discussed at the present time as a what if. And so stay tuned for how that's going to be paid. I think in the short run, if I understand it correctly, there is a 30-day waiting period for trying to start collections for any damages, and that NAR would most likely post a bond of some sort to try to get to keep the plaintiff lawyers from starting the collection process. But that all is yet to play out, and we're keeping a close eye on it.
On a related note, one of the questions that we've received is, what is the financial risk to state associations and local associations that are part of this three-way agreement? And again, we've reached out to outside expert legal counsel to help us with that analysis. But I think their initial review was that NAR is a separate entity from state associations and local associations. They have separate 990s. There's no joint and several liability between the organizations, at least based upon some of the preliminary documents that they've read. They're doing a more thorough analysis to ensure that's the case, but based upon preliminary review by these outside legal experts who know the organization fairly well, they've indicated that they did not feel that there was any financial risk to the state and local associations with respect to these judgments. Now, you might have other court cases out there that name state and local associations, so that's a different story.
There is a question or a comment, I should say, posed about why isn't someone explaining that there are typically two agents involved in the real estate transaction, that the national news is kind of creating some misleading or unknown information about the commissions being reduced by 30%. Why don't we have someone explaining this? I think your question or comment is only further emphasizing the need to make sure that we're communicating about compensations and commissions and compensations to others with our clients and customers in our state to avoid this idea that there's not a transparency. And again, you'll find, as you're well aware, that there's often times where people believe they understand a real estate transaction and that they don't. So unfortunately, we are not the legal counsel in those cases and are not necessarily privy to all the arguments that were made or the discussions within the courtroom. But again, one of the things that we can make sure you're doing is impressing upon the consumers how commissions work. The question about will the addendum C, WRA's addendum C, be abolished once the listing contracts and buyer agency agreements are updated? The idea is that it is something that is going to fill the gap until those WB forms are mandatory as of January 1st. So the addendum C abolished, I'm not necessarily sure. It might be modified to have a different perspective depending on what happens next. But again, once those WB forms are updated and out there on January 1st, the idea is that you would not be encouraged to use the addendum C any longer. Tom, would you like to share any of information regarding the new lawsuit in Illinois for the home buyers?
Sure. There has been the question is there a new lawsuit? Any information about the new lawsuit from home buyers? There's actually been one other lawsuit that has been filed by home buyers in the state of Illinois before the most recent one, which was filed within the last couple of days, maybe even today. The first lawsuit that was filed months ago was thrown out by the courts because they felt that there wasn't a sufficient antitrust claim, or there wasn't an adequate group of buyers to demonstrate a sufficient class. So they didn't have enough commonalities. So that was, they ruled in favor of the defendants there, but that case is being appealed. And we'll have to see what the appellate court says about that. There has been another case, as I mentioned, that was just recently filed by home buyers, again in the state of Illinois, that again, and they've named NAR and a number of different real estate companies, and they're saying that damages in that case could be significantly greater than the damages in the Sitzer case. So it's a very new case. We haven't had a chance to review it to see how it's different, but our understanding is that it uses the same or similar claims as the lawsuits brought by the sellers in the other two cases that we mentioned earlier.
And then there was a question, and again, there's a number of questions, and we apologize, we may not be able to get to all of them. So we will, if you named yourself within the chat, or the Q&A, we'll make sure that we respond to your question in a timely manner outside of this webinar. In addition, we encourage you to use the legal hotline in the event that you have additional questions or follow-up questions. And then one of the questions remaining is, how do we maintain fair housing and make sure the protected classes don't get charged a higher fee? Again, I think those are all really good questions for us to kind of consider as the final order comes through, and how there's one of the concerns about this idea that buyers pay out of their own pocket is if you already have someone that maybe is not qualified for a conventional mortgage, how do we make sure that we are not increasing the disparity between minority home ownership even further? And so those are all, again, good questions and potential consequences that both the State Association, the National Association, and others are looking into. Tom or Likey, do you have any thoughts in conclusion as we wrap this up?
No, all I can say is thank you for all the great questions. Scrolling ahead to see what you've asked us that we don't have time to answer on this webinar. We will get to your questions. They're all great ones. Thank you all.
Again, so one other thing, that if this is valuable to members and you'd like us to do another one as we get more information, we are happy to do this. This is an opportunity for us to communicate with you and answer your questions in a very efficient manner, to let others hear some of the questions that are being asked. And we will do this as often as we need to make sure that you guys have a thorough understanding of the lawsuits and what it means to you in your business, as much as we can and as much as we know.
And as much as we know at this time.
Right.
Thank you, everyone, for your time today. We appreciate you, and please, again, let us know if you have additional questions through the hotline. Have a great day.
Thank you.